Hi, my name is Sean. I'm from the Legal and Compliance Department, Orange D. Today, I'll be presenting misrepresentation by a real estate salesperson. What is it and why does this topic matters to you? What is misrepresentation? A misrepresentation occurs when the representor, the real estate salesperson, makes a false statement of existing fact with knowledge of its falsity, which induces the representee to enter into a contract. An act for misrepresentation arises under the law of tort. A false statement can be made either orally or in writing or by conduct. Any conduct designed to deceive the other party by leading the other party to believe that a certain fact exists when in fact it doesn't. For the misrepresentation to be operative, the false statement must relate to the present fact or to a past. Therefore, statements of the following nature do not count. What are those statements? Vague or exaggerative statements in the nature of puffery, and statements of a party's intention or opinion. Misrepresentation is a ground for relief only where it has induced a contract. Clearly, if a person is unaware of the representation or knows that it is untrue or that it does not believe it to be true, then he or she cannot reasonably have relied on or be induced by the representation to enter into the contract. Reliance may also be negated if the representee has independently verified the truth of the representation, although the failure to verify when provided with the opportunity to do so is not itself a bar to relief. If the misrepresentation has in fact induced the representee to enter into the contract, it does not matter that it is not the sole inducing factor. It could be one of the inducing factors, so to speak. There are three forms of misrepresentation, and let me bring you through it. The first form is the innocent misrepresentation, followed by negligent misrepresentation, and lastly, fraudulent misrepresentation. These types of representations are categorized based on the knowledge the representor had about the information they provided. Let's start off with fraudulent misrepresentation. Fraudulent misrepresentation is the most serious of all three. Fraudulent misrepresentation occurs when the representor makes a false representation, knowingly, recklessly, or carelessly as to whether it's true or false. For instance, a salesperson told the prospective buyers that the shop houses are allowed for storage or warehousing purposes when he knows that this is false and is not allowed. Let's move on to negligent misrepresentation. Negligent misrepresentation occurs when a statement made by the representor honestly believes in its truth, falling outside the scope of fraudulent misrepresentation, but without having the reasonable grounds for so believing. For instance, a salesperson, when informing prospective buyers, honestly believed that the shop houses are allowed for warehousing storage purpose, but the salesperson had no reasonable grounds to believe that it is such. The salesperson could have easily cleared the doubts by simply conducting an inquiry with the Urban Redevelopment Authority. Let's move on to innocent misrepresentation. Innocent misrepresentation are those made by a representor who honestly believe in his truth, therefore not fraudulent, and he is able to show that he has reasonable grounds to believe in his truth, therefore not negligent. For instance, a salesperson who informed prospective buyers honestly have the belief that shophouses are allowed for storage warehousing purposes. And he did his due diligence by conducting inquiry with the Urban Redevelopment Authority to confirm the same. Now, let's examine what is puffery. It was mentioned in the previous slides that puffery is a term used to describe wildly exaggerated or vague claims about a product or services. In this instance, property that no one could possibly treat seriously. For example, a restaurant claims that they have the best steak on earth. These types of statements are not considered misleading. Here are some examples of puffery for you to understand more on this concept. Rich with lush green landscape. Finest of luxury living that Singapore has to offer. Promising prestige, convenience, and tranquility. Luxurious and premium interior fittings. Breathtaking and panoramic view. Offers great facilities and features. Well-designed home that provides comfortable and modern living. Best property in Singapore and JB. High-end living at its finest. Living room is of nice size and stylishly decked out. Next, we'll look at the examples of misrepresentation. For instance, salesperson A told the prospective buyers that the tenure of a landed property they are considering is freehold when it's actually one with a 99 leasehold. A is therefore deemed guilty of making a fraudulent representation if he knows that the tenure is in fact a 99-year leasehold instead of it being a freehold, or he did not believe that the tenure of the house was freehold, or he had made the statement without caring whether the tenure of the property is in fact freehold. Let's take a look at this article which came out on the newspaper and also found on the web, whereby a real estate firm told to pay a couple almost 200,000 they lost in the New Zealand scam. Let's examine this article. Now, Faber Property marketed a residential project near Auckland, developed by New Zealand company Albany Heights Villas, herein thereafter known as AHVL. The buyers bought 3 units in the project in 2012. They made 2 payments, respectively, of 15,000 and 142,000 USD to Singapore-based Hunter Sterling and Company, which is the holding company of AHVL, or I would say the shareholder. It turned out that AHVL has had neither the land title nor the resource to develop the parcel. AHVL subsequently became insolvent, and probes in New Zealand showed that the people behind the project had creamed off substantial sums paid as deposits by many buyers from Singapore and New Zealand. So the couple was not the only victim. The buyer subsequently sued Faber Property for negligent and fraudulent misrepresentation. And now let's take a look what are their grounds for such claims. The buyer said that Faber Property had vouched that the developer had a good track record and investment monies would be held in a safe trust account. However, this is not true. The courts eventually found that Faber Property had not taken steps to verify the developer of its owners and had the purported experience and good track record. The courts further found that Faber Property was negligent in marketing the project and failing to ensure that the developer had secured the title to the land and ordered Faber to compensate 194,000 to the buyers, obviously as damages. Now let's move on to misrepresentation of remission of ABSD for a married couple. The buyer claimed that her salesperson advised her that as long as she sold the first property within 6 months of a purchase of the second property, the buyer would be refunded the ABSD payable for her purchase of the second property. After some considerations and acting on the misrepresentation made by the salesperson, the buyer then decided to purchase a second property at a purchase price of 1.2 million Singapore dollars. The buyer ended up paying $80,000 in ABSD and was not entitled for ABSD refund for a married couple. The buyer subsequently sued the salesperson for the sum of 80,000, being the ABSD incurred by the buyer. The buyer claimed that at the material time of the misrepresentation was made to the buyer, and when the OTP was provided to the buyer, the salesperson was and had actual knowledge and was fully aware that the buyer would be purchasing the property in her sole name. The buyer further claimed that the salesperson was also fully aware that she did not want to bear the ABSD on the second purchase of the property. Let's take a look at misrepresentation on the cooling off period following issuance of OTP. Now, in this case, the purchaser made an initial offer to purchase the property at 635,000 to the seller salesperson. The salesperson and the seller then discussed but rejected the offer. The purchaser then counter-offered with 640,000, a higher amount. Once again, the salesperson discussed with the seller and urged the seller to accept the offer. The salesperson then informed the seller that she could just sign and issue the OTP, and she would still have a cooling off period of 7 days from the issuance of the OTP to reject the offer. I must stress that this is not true. This representation was untrue. The seller was then reluctant to grant the OTP as the offer of that amount offered by the buyer, $640,000, was unacceptable to her. She had obviously the seller had a change of mind, and now she wants a higher amount, a higher quantum of $660,000. The salesperson was, however, persistent in informing the seller of the existence of the 7 days cooling off period, which the salesperson claimed would allow the seller to subsequently withdraw from the transaction after she had signed and issued the OTP. The seller eventually relented, and then dated OTP was duly granted to the purchaser. The seller subsequently sought to renege on the grant of the OTP, but the purchaser did not accept it. So what can the purchaser do in this instance? Obviously, take out a civil suit for specific performance against the seller to force the seller into completing the deal. Let's take a look. What did the purchaser do? The purchaser exercised the OTP and passed a copy on to the seller. As the seller did not proceed the sale of the property, the purchaser subsequently commenced legal proceeding against the seller for specific performance of the OTP. Specific performance is an equitable remedy, so to speak. As a result of the salesperson misrepresentation, the seller was compelled into selling her beloved property for a price that was at least 20,000 below her intended asking price. The seller was also put to legal costs and expenses when the purchasers commenced the action for specific performance against her, and she had to convey her legal title to the property to the purchaser as a result of the proceedings. So the seller obviously was not happy. She had to fork out legal fees to defend her suit taken out against her by the purchaser. Now, then this CA commenced disciplinary proceedings against the salesperson. So let's take a look at the charge one. So CA charged this salesperson for failing to render professional service to a client by misrepresenting to a client that she had a cooling off period of 7 days to withdraw from the sale of her property after the issuance of the OTP to the purchasers when there was no such cooling off period. This is in contravention of paragraph 6, subsection 1, read with paragraph 6, subsection 2b of the Code of Ethics and Professional Client Care. Now let's take a look at charge 2. For failing to be fully conversant and complying with the applicable HDB procedure in misrepresenting to a client that she had a cooling off period of 7 days to withdraw from the sale of a property after the issuance of an OTP to the purchaser when the applicable HDB procedures do not provide for such cooling off period to withdraw from the sale of the property after the issuance of the OTP to the purchaser, and instead provided that the OTP shall not be issued until the 7 days cooling off period is observed after the completion of the seller's resale checklist, in contravention of paragraph 4, subsection 1, read with paragraph 4, subsection 2e of the code. I know these two charges is wordy in nature. Please take your time to read it, the slides. Now, what's the outcome? Salesperson get charged already. Following a trial, the disciplinary committee, which obviously these DC people, salesperson asked me who does it comprises. They comprises of lawyers, engineers, and also people of respectable profession, found that the respondent was guilty of both charges 1 and 2 and imposed the following financial penalties and disciplinary orders on the respondent. So for charge 1, a financial penalty of $4,000 Singapore dollars was imposed on the salesperson, and the salesperson's license was suspended for 6 months. And let's take a look at charge 2 now. Salesperson was imposed a penalty fine of $2,000 Singapore dollars and suspended 4 months. And now some people ask me, 6 plus 4 equals 10, is it? It depends. It could the suspension could run concurrently, just like prison sentence. Not consecutively. Consecutively means 6 plus 4. Concurrently is together. So obviously it will be 6 months. Misrepresentation that the cost of home improvement program has been paid by the seller. Let's take a look. What is this case about? The buyers who are permanent residents of Singapore, the buyers are from Malaysia, Malaysian citizen, claim that the salesperson misrepresented to them that the seller had paid the HDB the cost of the HIP. The sellers are citizen. Obviously, the citizen of Singapore would pay much lesser, almost a subsidized rate for the HIP. That amounts in these instances $1,900. After some consideration and acting on the misrepresentation made by the salesperson, the buyer exercised the option to purchase. Let's take a look. Subsequently, the buyers received an invoice of the amount of $20,000 from HDB for the cost of HIP. As the buyers are Singapore permanent residents, at the point of billing, they need to pay the full HIP cost. Obviously, the buyers got a shock. Before they buy, they don't know that they have to pay this $20,000. They thought the sellers have already settled it, and the salesperson told them that the sellers have already paid up, But lo and behold, this is not, so they got a shock. The buyers claim that had they known the HIP costs were not paid by the seller, the buyers would have exercised the OTP. Obviously so, $20,000, maybe they would not have proceeded with the purchase had they known that they are liable to pay for $20,000. The buyers further claimed that at all material times, the salesperson was fully aware that the buyers were concerned, specifically concerned not to have to bear any HIP costs. Now let's move on to rental yield misrepresentation. The buyers allege a salesperson for misrepresenting the rental yield of a unit. Now this unit has an area of 420 square feet in a mall, Singapore mall, which I shall not name. The buyer claimed that the salesperson expressly represented that the unit would each be able to achieve a monthly rent of 15 to 20 Singapore dollars per square foot. Monthly rent of approximately 6,500 to 8,200 or words to that effect. In addition, the buyers further claimed that the salesperson also expressly represented there would be strong rental demand at this monthly price rental range, and that the unit was a perfect investment. The buyers claimed that they were induced by and acting in reliance of the rental yield representation that were made by the salesperson, because the buyers subsequently entered into the option to purchase and then exercised the said option to purchase and executed the sales and purchase agreement and completed the sales and purchase transaction of the unit price of Singapore $2.5 million. The buyers obviously, is not happy. It turned out to be untrue. They can't rent out their unit at the price that was represented by their salesperson, and then they subsequently commenced civil action against the salesperson for misrepresentation. And what's the reason for their ground claim? Let's take a look. The buyers claim that the rental yield representation amounted to fraudulent misrepresentation, as they were made recklessly, not caring whether they were true or false. The buyers claimed that there were no basis for any belief, and the unit was capable of achieving a monthly per square foot of 15 to $20 Singapore. At best, the unit could achieve a monthly rent per square foot of approximately less than half of what has been represented by the salesperson. Now, let me touch on what you should not do when presenting information about the property to the clients. You should not be guessing the facts, omit relevant information, making ambiguous or contradictory statements, making promises that you cannot keep, or making predictions without reasonable basis. For example, making statements, representation that the buyers will be entitled to 2 car park lots when they're only entitled to 1. There's this case that happened in Australia, in Sydney, whereby the buyers sued the developers and the salesperson for misrepresenting to them that they will have extra car park lot in the basement of the apartment. As you guys may know, that Sydney properties are very expensive. So a car park lot is worth tremendous amount of money. Okay, let's move on. Offer services without a reasonable belief or believing you can deliver them. Okay, do not make offer or guarantee that a certain promise will be delivered by either you or the developer, for instance, or the seller of the house. Now, let's take a look at when presenting information about the property to the clients. Be sure to give current and correct information. Use simple language. Now, you see if the buyer or either the seller, whichever party you act for, does is comfortable with only the English language or certain languages. Make sure that you, when speaking to them, speak to them in the language that they are comfortable in. Check that the overall impression is accurate. Back up claims with facts and documented evidence where appropriate. For example, if a salesperson, is making a representation to the prospective tenant that this premises can be used for example, a spa, then make sure that their claims are backed up by documents, checks with the URA. Note important limitations or exemptions. Correct any misunderstandings. This is also important. The salesperson should not be silent when they know that a misrepresentation have been made, and they should correct such misrepresentation, misunderstandings, and be prepared to substantiate their representations. With that, I come to the end of this presentation. Thank you for tuning in and hope everyone enjoyed my presentation. Should you have any questions, please write in to us at compliance_legal@oranged.com. Thank you so much.